Good afternoon, everyone. Thank you for joining us today for the second installment of our Elder Justice Lunch and Learn series. We are pleased to invite you back where we're going to learn today about eviction prevention and how we can help keep our older adults safe during the time of COVID, particularly as it relates to housing. I'm pleased to say that there are 612 of us joining this afternoon, and I think that really speaks to how much this resonates with us and how we seek to serve our clients better and more collaboratively. So thank you for joining us today. I hope this hour will be some time at which you can set aside to learn, and hopefully you're also getting to eat your lunch as well and get a little relaxation in. Thank you. So I want to remind you that this works because we can all be interactive. I hope this is like a really big office party where you feel comfortable asking the right questions. You can go ahead and drop those in the chat box at any time. We're going to go back at the end and we're going to give Ollie a chance to ask or answer some of the questions. And we're also going to be sort of hoping to follow up on some of those later. So if your question isn't answered today, don't lose heart. We will do our best to get to it. Please also feel free to connect with other participants in the chat. So I encourage you now to start off by dropping in and saying your name and what you do. How are you connected with elder justice and elder services so we can all get to know each other? Today we have not only closed captioning, but also ASL interpretation provided by the California Department of Social Services. We're pleased to offer this and welcome everyone to our table and hope that this makes it more inclusive so that we can all learn together. So as a reminder, this is our second installment, but we will be here for the next 10 months. And so if you could please mark your calendar for the third Thursday of every month from 12 to 1. The one exception with that is December. We've moved that up a week because we figured all of you guys are going to be partying with your coworkers and having a good time celebrating the holiday season and all of your good work from the last year. So again, we'll see you on the third Thursday of every month. And if you stick around to the end, we are going to drop the registration link for next month so you can be the first to register. So look for that towards the end. I want to be sure to thank Kaiser Permanente. They're our sponsor for this entire series and they make this possible. And I also want to say our planning partners, California Department of Social Services, California Commission on Aging, California Long-Term Care Ombudsman Association, the Office of the State Long-Term Care Ombudsman, California Department of Aging, Public Administration, Public Guardian, Public Conservators, and for this month, Legal Services of Northern California. We are deeply honored to have all of these planning partners as part of our team, and we really are appreciative of them bringing the community together. So thank you so much. So I think as senior service providers, we have all known for a very long time the issues affecting seniors and housing, those who are sort of on the edge of housing, those who are living with children, but it's kind of unstable, and those who are barely hanging on to sort of market rate apartment housing that may not entirely meet their needs. And I think in recent years, but especially with COVID, the rest of the world has awoken to our reality. And I just want to share some homelessness statistics here for you in California, where I am today. And that is that 40,000 people aged 65 and older are homeless in 2017. So the number of homeless people 62 and older jumped 68.5% across the United States from 2007 to 2017. And 40% of all homeless people who are over the age of 50 hit the streets the first time after turning 50. Meaning these people were hardworking individuals who simply, when they could no longer do those physically demanding jobs, were not able to maintain housing. And that is a travesty. It's especially difficult during COVID because we know that the best defense against COVID is housing and access to hygiene. And so I'm pleased to welcome Ollie Ehlinger here with us today. Ollie is not only a good friend and colleague, but he's also the managing attorney of the Solano County Office of Legal Services of Northern California. Legal Services in Northern California provides free civil legal advice and representation for low-income, disabled, and senior residents of Northern California. Oliver has served over 3,000 individuals in his legal service career and has represented clients in the state, federal, and administrative courts. He is a graduate of UC Davis School of Law and a North Carolina native. We are so lucky to have Oliver join us today, and I am pleased to turn the microphone over to one of my Solano County colleagues. So, Oliver, thank you so much.
Of course, thank you, everyone. Thank you for sharing your lunch with me. And of course, one of many thank yous to Nicole and her team. Elderly individuals who live in Solano, Contra Costa, and Alameda County are lucky to have her as an advocate on their side here. So I think I'd like to get started with a poll just to see what level familiarity folks have having served someone who is in the eviction process, just so we can see how much it's touched the work you've done. And so that should be popping up for you right now. I'm being told I cannot vote on this, but my vote is yes. And so once we get folks' votes in, we can see how much you folks have dealt with eviction in your work. It'll take a minute here to tally those votes.
Hey, Ollie. So it looks like that about 50% of the folks here today, and it's still tallying, have assisted a client with an eviction. And so that's a significant amount.
All right. And then I've just been told my mic is fuzzy. Is this any better?
Mm-hmm. Yes, that's much better. Thank you.
Oh, fantastic. I guess I need to talk into the mic or it doesn't work. Okay. Well, so luckily I haven't said anything too important except to thank Nicole for being awesome. Before we jump into this, I would like to thank Nicole again for the slide preceding my introduction regarding sort of the context of homelessness. And sort of by way of example, I have been an attorney with legal aid for about 9 years now. So I've been helping folks defend eviction or assert their housing rights for that period of time. And in those 9 years, I have noticed a difference as well. As we'll get into, there is a time period built into any sort of eviction process. And when I first started this work, people were able to sometimes secure new housing in that time period. However, about 3 or 4 years ago, I started noticing a difference when I have clients across the desk from me facing the loss of their housing. And I tell them, oh boy, I'm so sorry, we're still having problems with my sound here. Is this any better?
Yeah, that's a little bit better. Ollie, can you say a couple more things?
How is this?
That's much better. Thank you.
So I'm holding the mic. I feel like I'm stand-up night, right? But I appreciate everybody's patience here, although I'm sure everyone has a reservoir of Zoom patience at this point. So as I was saying, about 3 or 4 years ago, I started noticing a difference when I would tell my clients that their case might not be winnable. And it went from, I'm able to find alternative housing, to now I'm going to stay in my car for a little bit. And so to me, the link between an eviction and homelessness has become more direct. And sort of the second point I'd like to make is that I'd invite folks, as we jump into the details of an eviction, the details of the process, to think of eviction as the last failure in a long line of failures. Folks are getting evicted because they can't afford their rent, or they can't find alternative housing quickly enough, and they can't afford the rent, and they can't find alternative housing quickly enough because there's a fundamental disconnect between the prevailing wage and the benefits we allow folks who are retired or disabled and the market rate of rent. And there's a disconnect between those things because of disconnects in our educational system, because of our land use decisions. And so as we go into the details here today, I'd also invite you folks who have a voice in your community to expand on bigger solutions to the folks who can make those decisions. We're all here to pull people who are drowning out of the river, but it's also important to walk upstream and figure out why people are falling in the first place. So that's my soapbox spiel, and I hear that we're still having difficulties with the sound, so let's troubleshoot for 30 seconds here to make sure that folks can hear me when I go into the details. So we have a little text chat going on here with troubleshooting details. I'm going to pull that up, so folks, apologize for just a second here. I'm going to try and switch my microphone source. Give me 10 seconds here. folks.
Thank you, everyone. We really appreciate your patience. You know, it's been so interesting to work across area and sort this through. So go ahead and take a second, Ollie, and maybe just unplug the mic. We tried to be fancy. It doesn't always work for us. So thank you so much, everyone, for your patience.
So folks, I've now just switched to my computer sound. How is this?
Much better.
Yeah, So I hope we can edit me and make my voice sound sonorous in post-production here. I appreciate everybody's patience. And so let's jump into the details here. So this presentation, what we at Legal Services of Northern California train our new attorneys on evictions. It's a 4-hour presentation. We take a break in the middle. About half the folks fall asleep. And so we're gonna, Saunders, I appreciate that. We're gonna try and compress that into 35 minutes here. So we're gonna skip a lot of details, skip a lot of citations to the law, but if there's anything you wanna know more about, please type in a question. We'll have time for questions after my talk. And also tomorrow, my email's at the end. I wanna make sure that I sort of plug in any holes in your knowledge so you feel comfortable when someone walks in to your office dealing with this. And that's the point of this presentation. So when someone that you're serving comes to you and describes some level of losing their housing, you can identify where they are in the process, because identifying where somebody is in the eviction process is the step that you need to figure out whether they can stop it, and if they can't stop it, how much time do they have? And so that's going to be the goal. Can we stop this? And if we can't, how much time do we have? And then the last thing I'll say is that this is very California-centric. If we have folks who are out of state, the process is going to be generally the same, but the details will be a little different. And so glean from this what you can. So as Nicole said, I'm a legal aid attorney. I work for Legal Services of Northern California. Every county has a legal aid organization, and we provide free civil legal advice. So if you are not in one of the counties served by Legal Services of Northern California, and our service area is the Bay Area North, you might be served by California Rural Legal Assistance, Central California Legal Services. I think Bakersfield has their own, Bay Area Legal Aid. We're all there. We all try and do the same thing. And then we all sort of suffer from the same issue that I'm sure you folks are very familiar with, and that the demand for your services are just far, far outstripped by, what you're able to do and how many attorneys you have, how many folks you have. And so, if you're dealing with a client who might be losing their housing, we're going to do what we can, but we can't do 100% for 100% of the folks there because there just simply aren't enough of us. And so with that, let's jump on into the eviction process. So I want to lay out what the eviction procedure in California is, and I've split it up into 3 stages: the notice, the time prior to the court judgment, and the time after the court judgment. And then I want to talk about how COVID has changed those procedures. So we'll jump to the next slide. And Maria told me, save something pithy for the end so people tune in, but I can't do that. I'm not going to bury the lead. I want to start off by saying there is not an eviction moratorium in California. It's been reported through the press that there is an eviction moratorium, and that's not the case. Renters can and are being evicted right now in California. There are pauses and protections in place. It doesn't catch everybody, and it won't last forever. And so those details will sort out sort of in the second half of the presentation, but there is not a moratorium, and this is still happening. All right, so we'll jump in. So eviction is just the legal process by which the owner of a rented property removes a renter from the property. And the owner must first terminate someone's legal right to occupy the property, and they do that with a notice of termination. And then the owner has to commence and win a lawsuit in court that gives them a judgment. And with that judgment, they can get the sheriff to come out and physically remove someone from the property. And so breaking down those steps and figuring out where your client is in that process is the first step to giving them the best help you can give them. So let us jump right in. Oh, repeating myself, I see. But like we said, this help should determine if someone can win the eviction and remain, or if not, how much time do they have? So let's jump straight into the notice period. So in order to acquire the right to go to court and remove someone from a property, the owner must terminate that person's right to occupy the property with a termination notice. And so how we should be thinking about notices are, can we fix the notice? And is this a proper or valid notice? And so can the renter fix this notice? The two most common notices folks get that give them a chance to fix it are the notice to pay rent or quit and the notice to perform covenants or quit. And in order to fix those notices, in order to fix a pay rent or quit notice, the renter must pay rent exactly in the amount that's listed on the notice before the end of the third day. A notice to perform covenants or quit is a notice informing a renter that the owner believes they are breaking a lease term. The lease says no dogs, and you got a dog. The lease says you got to mow the lawn, and the lawn's up to your waist, right? And so the renter has 3 days to fix that violation. Get rid of the dog, mow the lawn, right? That's a simple thing. And so sort of the takeaway from that is, even if there's a sort of a dispute as to whether these things are correct, if the person you're helping is able to fix the problem while the notice is out there, we encourage them to do it and then sort of, resolve an underlying issue after that. A second question to ask about any notice is a notice valid, right? Because if a notice isn't valid, once it expires, the property owner shouldn't win an eviction based off of the notice. So a notice that demands an incorrect amount of rent is not valid. A notice that demands rent when there's severe repairs that need to be made that haven't been made shouldn't be valid. And then a notice that demands a renter apply or comply with a lease term that's not in the lease, or do something when they haven't violated the lease, those shouldn't be valid. So next slide, please. Another set of notices that renters get, we call them periodic termination notices. They're just a notice that says, you got 30 days to move, you got 60 days to move. They might not state a cause. And it's when someone's been living at a property for a while and they become a month-to-month tenant, and it's just sort of saying, we want to end the property, we want to end the relationship, right? And so one question to ask as to whether those notices are valid is, has the renter been given the appropriate amount of time? And so someone who has lived in a property for over a year is due a 60-day notice. And someone who's lived in a property with a Section 8 voucher, they're due a 90-day notice. And so one of those, if you're getting a different type of notice, it might not be correct. So let's move on to just cause. Just cause refers to the concept that an owner has to have a reason for evicting or terminating a tenant who rents there. And until January 1st of this year, California was not a just cause state, which means that, in places like Oakland and places like San Francisco and LA, those cities required property owners to give a reason when they wanted to evict somebody. Across the state, otherwise, though, a property owner, as long as they gave proper advance notice, could evict anybody. So they could get rid of you without a reason, no matter how good a tenant you've been, no matter how long you've lived there. The California legislature passed a new law, which is required that some property owners give cause to folks. And so who is required to get cause in a termination notice? And they're renters who rent subsidized properties. And so that includes folks who have Section 8 vouchers, that includes folks who are in HUD housing other than a voucher property, and that includes folks who are in low income housing tax credit or tax credit properties. And there's a big overlap between affordable senior housing and tax credit properties. So if you're helping a client in one of those properties, they're due cause. Mobile home owners and long-term RV residents, and an RV resident becomes a long-term resident after 9 months. Those renters renting the space, they're due cause before an eviction. And once again, there's also an overlap between mobile home owners and RV residents and elderly individuals. Mobile home parks are one of the last bastion of affordable housing for folks. And so those folks get a little extra protection before they can be terminated. And then after the new state law, renters who have lived, let me step back, the new state law, you might have heard of AB 1482. It's complicated, and as all pieces of legislation are, it's the result of some pretty detailed compromises, and so it doesn't cover everybody, and the folks that covers it, it's sort of hard to make a bright line rule for. But the best rule for renters who are owed cause before a landlord terminates their right to be there are residents who have lived for over a year in multifamily housing built after 2005 or corporately owned single-family homes. So a corporately owned single-family home generally refers to properties that large real estate entities purchased after the last crash. If we remember the last one, now that we're in the new one, go back to the last one. Landlords such as Granite Ranch Opportunities down in Southern California, Invitation Homes up here in Northern California. These are corporate owners of single-family homes. And if you have someone who's lived in a property they own for over a year, then they're due cause before that owner can terminate their tenancy. And so the takeaway from this is it's complicated. So if you have someone who's getting a 60-day notice, getting a 90-day notice, if you can get them to a legal aid attorney, we can do our best to figure out whether that's valid. All right, so a review of the notice period. It allows the renter to either reinstate or save their tenancy by complying with the notice or know the time frame before the court action will start. So moving on to the next portion is the prejudgment period. So the first business day after that last day of the notice, the owner can go to court to file a lawsuit to remove the renter. That lawsuit is called an unlawful detainer and is often abbreviated as a UD, and I'm going to go ahead and say UD from now on. The owner then must serve the UD paperwork on the renter, and once served, the renter has 5 days to file papers at the court to respond. And if the renter doesn't respond, the owner wins the lawsuit by default and jumps to the post-judgment stage, which we'll get to in half a second. And so when someone is helping you, or excuse me, when you're helping someone with evictions, there are tons of papers that are flying around. And I'm trying to highlight the two most important papers that when you're helping someone with an eviction, you should be looking for because they trigger the most important timelines. And so I've made a link to the court summons in an eviction here. And I'm hoping that we can, oh, fantastic. Maria, you're amazing. So this is the court summons in an eviction lawsuit. And this is the paperwork after the lawsuit is filed that a renter will receive. It displays all the great characteristics of court paperwork. It's confusing, it's overwordy. They use, that looks like 2-point font. But if you see something that looks like this, it's important because that triggers the renter's time frame to respond, and they must respond within 5 days. And there are all sorts of rules about whether service is valid, but it's rarely worth fighting over that. Once you see this paperwork, you got to be thinking about how to get to court. So I wanted to put the link to this, and I wanted to make sure that it was there available for folks to, if you see this paper, then you know the time frame is short. So Maria, if we don't mind, we jump back to the slides here. Fantastic. So you've got that summons. Now you need to respond, and the renter's response is anything they would raise to say that the eviction is invalid. The defenses, right? I don't owe all the rent because I had a broken heater all winter, or the property owner can't remove me with a 30-day notice because I've lived at this property for 5 years. And so the renter doesn't need to use legalese. The renter doesn't need to attach a million receipts. They just need to say enough in the answer to let the other side know what they would say at court. And that's important because sometimes the thought of filing court paperwork is daunting to folks. And because the timeline is so short, get it in there. It doesn't have to be perfect, but it's got to be in there. Once the court receives the renter's response, the owner asks for a trial date, which the court used to set within 20 days. COVID has changed that, but before then it used to be within 20 days. anytime before that court date, if the renter left the property or if the renter worked out a settlement, there would not be an eviction judgment. And that's sort of another important point to make. The eviction process, getting evicted itself is tough enough, right? You're removed from your home. But the credit marking on somebody's record of a court judgment for an eviction is also a huge barrier from getting new housing. And it follows folks around for 7 years. So oftentimes when an eviction is just not winnable, we tell folks to prioritize moving because it'll make things tough now, but it'll make finding housing later in the future, right? But if you're unable to move out or settle it, then you got to go forward before the judge. And so that's the next slide. And so the court never grants continuances for an unlawful detainer court date, period. You cannot move it. It's there. You know, they'll wheel a phone to your hospital bed if you're there, but they will not give you more time, and that's it. And so the renter needs to be ready on the day of trial with all the evidence that supports their case, receipts that they paid the rent, reports from code enforcement that the place was a dump, witnesses to show that you didn't do, you didn't do what the notice alleges you do, and you got to have it ready. If the court rules for the renter, then you go back to before the notice and your tenancy is reinstated. If the court rules for the owner, then the owner gets a judgment and the next process starts. And so the next slide is, this is the second most important piece of paper in an eviction. This is called the notice to vacate. It is issued by a sheriff's department, and it's if eviction is a 17-step process, this is step 16. This is the 11th hour. This is where the sheriff indicates on the day and time when they will physically remove someone from the property. And so if someone is coming to you with this notice, sort of the options are extremely limited. All right, so the post-judgment period applies to a renter who did not respond after they were served with the court paperwork, or who lost at trial, or who entered into a settlement and broke the terms of the settlement. You settled the case and you said, I promise to catch up on my rent, and you miss a payment. And that allows the owner to get a judgment and move forward. The owner requests that the sheriff perform a lockout, and the sheriff posts that notice to vacate, that last slide, and says, I'm coming back out in 5 days at least to lock you out. The notice to vacate must give someone 5 days, but by local practice, sometimes folks get a little more time. In Solano County, our sheriff only does lockouts Tuesdays, Wednesdays, and Thursdays. And so, someone might receive a notice on a Thursday that the sheriff's not coming out till the next Thursday. You get at least 5 days, generally 7 days notice. There is one court process to postpone a lockout. It's called a stay of execution. And the renter must be able to show to the court that the lockout will cause extreme hardship. And that's beyond the normal hardship of just becoming made homeless. And sort of a point I make to my clients is that nobody who is an eviction judge ever was homeless. And I feel like that's a blanket statement. I feel like I can say that. I know it's a generalization. The folks who become judges are folks who are lawyers, and folks who are lawyers are folks who don't understand how folks live day to day. And I think I can make that general statement too. If there are any judges on the line, I apologize. And so to put in a declaration that, it's going to be tough to be homeless, it doesn't convince a judge, unfortunately. And so when folks are trying to stop a lockout that's coming 2 or 3 days down the pike, you got to connect it to a medical condition. You got to connect it to children you're caring for, because just the upheaval that comes with losing your home, sadly, is not enough to carry that legal standard we found in our practice. So the last thing I'll say about stays is the court has very complicated rules to request a stay of execution. And so the most time-pressing thing that a renter needs to ask for is the hardest thing to do. And so folks come to you with that notice saying, I've got 5 more days. And generally, even if there is technically an option, it's usually not practical to spend your time to get the court to give you more time. And it's usually more practical to try and find a plan B with that. So let's move on quickly here in the last 10 minutes to chat about what COVID has done to this procedure. So what we talked about is how things used to work before COVID, and there are a few changes thanks to COVID-19, but I will repeat verbatim, there is no eviction moratorium in California. There are pauses and protections in place, but renters can be and are being evicted right now. And we'll talk about who might fall subject to it. So what are the changes? The most pervasive change and the change that's had the biggest effect to procedure is an action by the Judicial Council. And the Judicial Council is the governing body of all the local courts in California. And it issues procedures for the court in any sort of court case that they're doing. And after the Judicial Council issued emergency rules that state after April 17th, a UD, that eviction lawsuit, cannot move forward unless the UD is necessary to protect the public health and safety until 90 days after the governor ends the state of emergency. So right now the governor has declared a state of emergency, and that's sort of flipped on all sorts of powers and protections separate from evictions. And until 90 days after that end, the Judicial Council has said most evictions are mostly paused. And sort of by way of context, when the governor declared a state of emergency over the Camp Fire, that state of emergency lasted, oh Lord, the fire was in November, and I think that state of emergency lasted till May of the next year. So a state of emergency can be a long period, and we'll talk about the significance of that in the next slide here. So only evictions that implicate the public health and safety can move forward. That term is not defined, but it should not include people who are just behind on their rent, who just overstayed their lease or a 60-day notice. Because the governor's declaration of a state of emergency might be a super long period, and because the Judicial Council is a procedural body and can't sort of issue substantive laws that affect people's property rights, these protections that are currently in place, I think, were never intended to be in place this long, and likely will not be indefinite. And so this time frame we're on now is likely to be changed. My guess is in the next 2 or 3 months. We'll talk about what the legislature is doing in a bit, but there are already lawsuits by property owner groups to repeal the Judicial Council pause. And so, stay tuned, and maybe Nicole will asked me to write up an update for everybody. But right now, most, we'll call them ordinary evictions, non-payment of rent, and overstaying your lease, those are paused. So next slide, please. So what has Congress done? Not much. Congress has banned evictions for non-payment of rent in federally subsidized properties through, 9 more days here. Under our Judicial Council rules in California, these evictions are paused anyway. And so Congress's actions don't add any extra rights for California renters right now. What has the governor done? The governor has declared a state of emergency, and by invoking the state of emergency, rental increases over 10% are banned. So if you're seeing folks who are coming to you with large rental increases, those are illegal right now, regardless of whether you live in a rent-controlled jurisdiction, regardless of whether the property that person lives in is covered by a subsidy, is covered by the new rent control law that passed in California and started January of this year. People should not be seeing large rental increases. If you see that, send them to legal aid right away. The governor has allowed local jurisdictions to pause evictions based off of COVID-related non-payment of rent. And so these are the executive orders from the governor that are being characterized in the press as a moratorium, and they are not a moratorium. It's an enabling of local jurisdictions to stop only a small subset of evictions, and that's non-payment evictions based off of COVID, right? And so if someone who got a 60-day notice and couldn't move, maybe because they lost their job because of COVID, but the landlord's not demanding rent, just saying you need to move, those folks are still vulnerable to an eviction under what the governor has proposed. So it is not a moratorium. What has the California legislature done? None. No actions. Nothing so far. There are pending legislation, and I think that the biggest legislation or package that seems to be getting the most support from both sides is a bill that would change rent that somebody owes and was unable to pay during the emergency because of COVID. I had my job, I lost it because of COVID. I had my job, I had to leave it because I got sick. And take that rent that they would have owed for that period, and the landlord can't evict them for it. The landlord has to evict them, or excuse me, has to collect it in another way. And so it's changing some rent to consumer debt. And so what that would do were that to pass is once the judicial council rules are lifted, then those folks who couldn't pay their rent would be protected for a little while and would have a chance to enter into a payment plan. What that wouldn't do is protect folks who just couldn't find other housing or folks who are being evicted for another reason. But this seems to be the compromise that's fermenting right now, but that's the best knowledge I have. And next slide. And so locally, other counties and cities have passed their own patchwork of protections. And so in Solano County has already passed the protection that the legislature is thinking of passing. It's once the judicial council rules are lifted and all evictions can move forward again, a landlord wouldn't be able to sustain an eviction for non-payment when someone couldn't pay their rent during the emergency because of COVID. But right now, these evictions are all paused by the judicial council. So the next slide is kind of the takeaway from all of this. And the takeaway is, how long does an eviction take? In pre-COVID times, it'd be however long the notice gives you, plus about 5 to 6 weeks. During COVID, for most minor lease violations, including non-payment of rent, it's paused indefinitely. For anybody whose eviction started before April 17th, and so before those judicial council rules went into place, it's going to go through the normal timeline and the normal process. And so those folks are still subject to a sheriff's notice. And that includes folks who settled their eviction and might breach their settlement. And then after the judicial council rules lift, which nobody knows when that'll be, but I cannot imagine they survive the year. I cannot imagine they last much longer. The eviction timeline will start again, and we'll be back in that pre-COVID timeline. And there might be a carve out for some renters who couldn't pay their rent for some reason. But other than that, I believe that sort of it'll go back to business as usual. And I believe that is the last substantive slide, which gives us about 20 minutes for questions. And I saw some popping up as we go. So I don't know, Nicole, how you want to.
Oh my gosh, Ollie, you have some good questions here. So thank you so much for your presentation. But these are some very smart people. So I want to prepare you. They've got some good questions. And the one I want to start out with is a really interesting one. And it comes to us from Renee. And she's with the Public Guardian's Office. And her question is, what about squatters' rights? Okay. How do you remove a squatter without having to go through this process? And she's specifically saying, you know, we have an elderly clients and they have people that have sort of moved in and they're taking up space. How do you deal with those kinds of issues?
Yeah, so the process I went through, the notice and the unlawful detainer, that's a process that only applies when someone is a renter, right? And so a renter is someone who occupies a space and subject to an agreement. Agreement doesn't have to be written. It can be oral. I move into the room in your house and I pay you $500, but there's some sort of exchange, right? And so when we come into a situation where we're using the word squatter, there might not have been that exchange. And so that person, that squatter, is not a renter and thus is not protected by these renters' rights. And so you got to be careful, right? Because some folks say, I got a squatter in my house, they've been paying me rent. Well, then they're not a squatter. But if it's just someone who moved in and didn't do anything in exchange for that room, which can also be caretaking in some cases, probably the best way to remove them is a restraining order. And restraining order procedures are moving on, unabated. And so someone, especially an elderly person who's being deprived of the use of their home that they need for their health and their safety and security, that person is probably eligible and entitled to an elder abuse restraining order to remove someone who does not have a legal right to be there. And that would be the best way to, that would be what I would suggest to do.
So Ollie, okay, that makes me think, does rent always have to be an actual exchange of money? So like if those people moved in, they said like, hey, I'm going to do your yard work and my girlfriend's going to, pay the bills and take care of the house. Like would those people then qualify as renters because there's been an exchange of services?
Oh boy. Yeah. So that's a very great question, right? And so well, it's a great question, but it's also the gray area question. And so what I would say is, yes, it can. Rent is not defined in state law. In certain jurisdictions, San Francisco has its own definition of rent, and it does include services. I would say any money exchanged, even if you're not paying rent, even if the person living with you, they promise to pay your utilities, your mortgage, your property taxes, that's going to bump them over into a tenant. Someone who's doing specifically defined work for you, like a caretaker or handyman work, that's gonna sort of one, probably bump them to tenant status, and that also two might put you on the hook for employee-employer rules, right? And so we definitely would caution folks about availing themselves of that kind of situation. Right. So I think in the case you're describing, that's getting pretty close to someone establishing tenant rights because they're there to do something of value. And that's an exchange.
Okay. Thank you. So Maria has two really good questions and I'm going to put them into one. And so the first thing is, what constitutes severe repairs?
Mm-hmm.
And can someone ever go to court in place of a tenant if they're not able to attend? If they're, you talked about being bedbound, is there any way someone else can go in their stead?
So we will start with the first one. The California has what's called a warranty of habitability in all rented premises, which means that anything that an owner rents out is promised to meet California Housing Code. And California Housing Code is laid out actually specifically, and I can give you the site. It's Health and Safety Code section 17920.3. And that lays out about, oh Lord, I think it's 13 or 14 enumerated qualities that all rented properties have. And so it's what you would expect. It is, everything has to have electricity, running hot and cold water, has to be free of debris, free of vermin, right? It can't have visible mold growth. Every rented premises has to have a heater. Rented premises do not have to have air conditioning. That is not required by state law. And so I can feel our friends in Bakersfield and Fresno like cringing, but that is not required even for senior folks. And so any rented premises that substantially lacks one of these enumerated qualities, it falls below the warranty of habitability. And so if the property owner is aware of that and has not adequately remedied it in an appropriate amount of time, which depending on the severity of the repair can be anywhere from 48 hours if you don't have electricity or running water to, like a week if your blinds are broken or something. Then that's a repair that needs to be made, and that's something that impacts the legal value of the property. If you're renting a place for $1,000 and you don't have heat, it's not worth $1,000 anymore. And so the owner is not legally entitled to get $1,000 out of you. And that would be your legal defense in an eviction. But so the most appropriate thing for someone to do facing this situation is to communicate with your property owner in the way you normally communicate with them about the repair. Text them, talk to them, hey, I don't have heat, and then follow that up with a writing. Hey, I talked to you, on Tuesday, and I told you I don't have heat. I hope I have heat by Thursday. So you're keeping a record of that. So that's what I would. So to answer the question in one sentence, which apparently I'm horrible at, a severe repair would be, besides a tongue twister, a substantial breach of any of those enumerated qualities that all rental properties have to have that are in the Health and Safety Code. Switching to the second question, Nicole, can someone else appear for a renter in court? That's incredibly difficult to do. That person would have to show, a lawyer can do it, for one. And then two, another person could do it if they could show sort of a legal relationship. A power of attorney could probably do it, but would need to make sure that the power of attorney they have is valid. if someone is facing this situation, my advice is call the court clerk right away. No matter who else you talk to in the court, the clerks are always the best and most helpful people. Call the court clerk right away and indicate you need a reasonable accommodation because you cannot appear at your court hearing because of a health issue, and they'll work it out somehow for you. I found that the clerks are the ones who can work magic for you.
Excellent. Thank you. Glad to hear the clerks live in the real world with us and they can help us out.
I think the real world bogs them down a bit, which is why they shut their phones off at noon, but I don't blame them.
Yeah. Well, I see some questions popping up from my ombudsman colleagues across the state. So I'm going to put those a little bit together and see if you can help us out. So I see, basically you talked about a timeline around evictions related to the amount of time that someone had lived in a property. Mm-hmm. And the question is, do those timelines sort of pertain to what you would call a residential care facility for the elderly, or what you might know as assisted living? And maybe you could talk a little bit about your work in evictions in skilled nursings, or if you know of any of the rights that those residents possess.
Sure. I think this might be a briefer answer. I think anywhere you have a rental agreement, the rules and timelines I talked about apply. Things are different for skilled nursing facilities or SCIF. There's definitely, there is an internal appeal right before someone is removed. And Nicole, you probably could speak on this about 5 times more knowledgeably than I could. But there's also a placement requirement. And to be honest, those rules just aren't as, I don't know them quite as well off the top of my head, but there are a little more protections for someone in a skilled nursing facility.
Thank you, Ollie. And I should say to our friends here, in October, in honor of Residents' Rights Month, we will be focusing on issues affecting those who live in long-term care, as well as elder abuse in facilities. So for those ombudsmen and others, I encourage you to make sure to mark October on your calendar.
And then to piggyback off of that, Nicole, we see a lot of folks who have been involved with the ombudsman or adult protective services, and they are placed in room and board. Mm-hmm. Or facilities that call themselves room and board, and those folks are subject to the same landlord-tenant protections. So even if they're getting a little extra, they're promised a meal or something, that doesn't fundamentally change sort of the contractual relationship.
Mm-hmm. Okay, thank you. So we have a great question from Dawn, and she asked, why do some affordable housing developers, they won't accept a third-party vendor to seek rental assistance for back rent, security, deposit, first month, etc.?
So why don't they do it? God knows, I don't know that. It might be some sort of indicia that the person is unable to pay rent. If they need help, they can't afford it on their own. But what I will say is that is now illegal. About 2 years ago, the California legislature required a housing provider to accept payments from a third party to assist somebody. It's Civil Code 1947.3. And as long as the third party assisting is willing to sign an agreement saying, hey, we third party aren't becoming a tenant, we're just helping this person, then the property owner, has to accept that payment. And so if you're running into this situation, find your legal aid, talk to your county council, talk to whoever you can. This is something that needs to be pushed back on because these third-party folks who have money to help folks prevent homelessness, that's where it needs to be going. That's how it needs to be pushed. And so if you're running into resistance at the affordable housing developers too, that drives me a little nuts anyway, because they're already, living off our tax dollars, right? So there needs to be pushback on that. That is not a legal practice anymore.
Thank you. That is very helpful. And Don, I saw you ask an earlier question about Alameda County, and I would encourage you to contact Legal Assistance for Seniors, LAS. They do great work down there, and they'll know some specifics about Alameda County. So Isaiah asked, what about a client who transferred legal ownership of a house the client paid for over to a family member who wants to evict them? The client no longer has mental capacity, but did when the transfer occurred, and the client still lives in the home with their spouse who provides care.
Oh, but you know what? I think some of the saddest situations we get in our office are those that involve family. and those that involve probate. If someone transferred property, even if they owned it, whoever they transferred it to becomes the owner, and the owner has the right to manage the property in any way they want. And so if it's just a simple transfer and that person, the original owner, your client, did not retain any rights for themselves, then the owner can evict them. Straight up. They got to follow the process, but they can do it. A lot of times in these transfers, especially if a trust is involved, the owner, the person who transfers the property in the first place, they retain for themselves what's known sometimes as a life estate, which means, I'm giving you this house, but I have the right to stay here till I die. And that's not an uncommon thing. And so I would look at the sale documents. I would look at a trust document if that's involved to see if that right exists. But if it doesn't, then unfortunately that person is vulnerable to an eviction. Okay.
So we have a sort of similar question coming up here, which is kind of on the squatting topic, which is, you have, let's say, a couple and they're living in a home and one begins to maybe lack some capacity and they agree to let maybe a child or a long lost nephew or someone move into the home, but the other adult does not agree to that move in. So what happens when there's two owners on a property and they are of different minds?
Oh, Lord. Okay. So that's also, and then once again, on the theme of you never hurt anybody like you hurt family, right? When you have property owned by more than one person, unless there's an agreement to the contrary, which in owning a home is not common, all the owners are sort of the same level. So any owner can bind the property, can rent the property. So if owner A tells you you can stay here, then owner B can't override that, right? They bound the property. And so as long as that, they entered into the contract properly. So if owner A didn't have capacity at the time they entered the contract, allowed the nephew to move in, then it's invalid. But if they did and owner B just disagrees with them, then unfortunately they're, in order to sort out the legal right of the person who's staying there, there'd have to be a dispute between the owners in court. And ultimately a court would probably resolve that by telling the two owners, you got to sell the property if you can't decide how to operate it. So that's kind of theoretical. In the practical sense, right? If you've got someone staying there and owner A lets them stay there and they're not causing any problems, owner B is going to have a hard time getting them out. If they are causing problems, owner B is able to get a restraining order, an elder abuse restraining order, a civil harassment restraining order pretty easily, or owner A and owner B can work together to evict the person. But short of violence and harassment, the owners are probably going to have to be in concert to remove somebody who has a valid right to be there.
We have one last question that I want to ask you, but before I do that, I'd like to remind everyone that we are going to be sending out these slides by next Tuesday, and you'll get an email letting you know where you can access them. As well as Ollie's going to take some time tomorrow and make sure we have answered all of these questions. So even if your question has not been answered today or you just haven't typed it in yet, go ahead and drop that in the chat function and we will be sure to get all those tomorrow. And we thank Ollie for his time and his experience. So our last question today is, can you offer any guidance around reverse mortgages? Can you offer any sort of words of wisdom or how that affects folks who maybe have had tenants or what that means for them?
Don't get them. No, so right. A reverse mortgage is there for someone who owns their house outright and then needs to tap into the equity. And so for a lot of the seniors that we help, a medical bill, loss of income, that's the only way to stay in the home. So I guess the two things I would say is if you have a home and you need the money, a reverse mortgage is going to make it very difficult to pass that asset on to your children. And so I would encourage someone thinking of that to talk to a HUD counselor and to talk to a trust and wills attorney. The second thing I would say is make sure that the reverse mortgage is federally backed, because all federally backed mortgages has to allow the survivor to remain in the home till they pass away. So if the mortgage is just in husband's name and husband dies in 2022, but wife lives another 4 years, if you got a private mortgage that's not federally backed, then the mortgage company can demand sale after the husband's death and can remove the wife. And so you want to make sure that you get one of those covered mortgages that allows sort of the survivor. They call it the widow issue. If you have tenants in a property that you put a reverse mortgage on, and your heirs cannot pay off the mortgage once you pass away, the tenants will become tenants of whoever buys the property at the foreclosure sale, and they've got tenant rights, under the foreclosure sale. Just because a property sells, it doesn't mean the people who are renting there are automatically removed. It does mean the new owner probably will get rid of them, because anyone who's purchasing a home at a foreclosure sale is probably not looking to become a landlord, but is looking to flip an investment. And so that person will probably have to move, but they won't have to move the moment you die. They won't have more of it. They won't have to move the moment you die. They won't have to move, the moment it sells. And so it will give someone a little bit of time. A renter in a foreclosed property has a little longer runway than renters normally. And so generally those protections are a little better.
Thank you, Ollie. That was a great way to end our session with you here today. I want to let you all, you've dropped some great questions in the Q&A and in the chat. We will take those and we will have Ollie answer them tomorrow. Ollie, thank you so much for not only being on the show today, but also for all that you do on behalf of seniors all over Northern California. So thank you so much. We really appreciate your time. Everyone's been very appreciative of your comments and all that you do.
Yeah, well, thank you so much for having me, Nicole. It's an honor to work with you and everyone else who's out there sort of on the front lines, helping folks who need the help the most. I hope everyone's staying safe and staying sane. And I appreciate your time today.
Absolutely. Thank you. So next month, we will be joined by Lisa Nirenberg, Executive Director for California Elder Justice Coalition, and Lori Deligrammaticus, the Executive Director for National Adult Protective Services Association. They're going to talk about national and statewide trends as it relates to elder abuse. Thank you so much, everyone. We look forward to hearing from you next month.